Is the Freedom Amendment reckless? Let's talk about it. Hi, everybody. I'm John McLaughlin with the Iowa Firearms Coalition, and the Freedom Amendment, which will be on the ballot November in Iowa, the backside of the ballot, is starting to get a lot of attention in the press, and the anti-gun crowd is certainly coming out. So I brought in Richard Rogers to kind of go through some of the articles we've been reading and the Facebook groups that are coming out. Richard is our volunteer lobbyist, and although he's not an attorney, he's certainly an expert in all things Second Amendment. So Richard, first of all, thanks for joining us. And let's just start with, we're seeing these words reckless with regard to the Freedom Amendment. What's your initial reaction besides maybe laughing a bit when you read that?
Well, thank you, John. It's good to see you. Yes, that's right. In fact, I think maybe our opponents have trademarked that, or they might as well trademark it, because they're using that regularly as a catchphrase, reckless amendment.
Mm-hmm.
I have to laugh a little bit. You know, fundamental liberty is not reckless.
Right.
In fact, in testimony the other day, I said something to the effect that our opponents portray this as reckless or dangerous. I'll sometimes say dangerous. Liberty is dangerous. Mm-hmm. Individual liberty is dangerous. It has to be respected,
right?
Like fire. But it's more dangerous to fail to protect our individual liberties. I think you'd agree with that, John. Once liberty is lost, it may never be regained.
Right.
That's what's truly dangerous. The Freedom Amendment, as we call it, will put strong protections for the right to keep and bear arms in Iowa's Constitution for the first time. As you know, John, we're one of only 6 states that doesn't have that protection of any sort in our Constitution. And it's a club we really don't want to be in, because it's California, New York, New Jersey, Maryland, and Minnesota, and Iowa. So what doesn't fit there?
Yeah. Now, we're not trying to rewrite the Second Amendment. And this is not something we just came up with this last legislative session. This is more than a decade in the works. And what we're trying to do is offer protection. And I think you've described it as, you know, if the Second Amendment is your suspenders, we're trying to put a belt around there just so your pants don't fall down.
That's right. Well, John, again, we don't have it in our state constitution. And until 2010, that was very important, because the Bill of Rights was never intended to apply to the states. It was only in 2010 that the Supreme Court of the United States said that the Second Amendment does apply to the states and to their political subdivisions, and that they have to respect it. Mm-hmm. Prior to that, it was not so considered. After the Civil War and the 14th Amendment and its Equal Protection Clause, Supreme Court slowly started to, what they called, incorporate aspects of the Bill of Rights against, as they put it, the states. Mm-hmm. But it wasn't until 2010 that happened. Well, 2010 is the year in which we got the old May issue weapons permit scheme in Iowa. We got rid of that and got the new shell issue scheme. It went into effect in 2011. It was at that time that we began to work on getting this amendment in our state constitution. The gold standard for language that would protect these rights was considered to be this strict scrutiny clause that we have in our amendment. And so for all this intervening decade plus that we worked to get this before a vote of the people to get it into the Constitution, we have assumed that by requiring strict scrutiny, which we can talk about here in a minute, that the courts would have to actually respect the right to keep and bear arms. The problem is that I've always said that the right to keep and bear arms is the canary in the coal mine for our other rights. It's the right that was so easily overlooked, kicked under the carpet, actually abused, ignored. And if they can do it with that right, which is, of course, the ultimate guarantor of our other rights, they can do it with any fundamental right: freedom of press, freedom of speech, freedom of religion. So we wanted to protect those rights. And yet courts still developed this, back in the 50s, they developed this 3-tiered system for reviewing cases. One is a rational basis, which basically any restriction on our lives can pass the rational basis. The government's got a rational basis for doing this, the courts are going to let it go.
Yeah.
Intermediate scrutiny, the courts will say, well, the state has to have an important interest at stake here, and you know, does this restriction regulate that? And if it does, we'll let that go. But strict scrutiny is the highest level of judicial review, and it says that the government must have a compelling or a very important interest at stake, and that any restrictions on the fundamental right must be very narrowly tailored to address that compelling interest. And that's a very tough standard. It's a dual standard, and it's a very tough standard. So for all these years, we wanted to get that in the law, and this has been what those who oppose us have fought against.
Right.
Why? Because it will make gun control difficult to pass. It will make people control, which is what gun control is, difficult to pass. They want it to be easy.
Or you were trying to look into the future here a little bit when we're crafting the wording on this, so that you know, let's say 5 years or 10 years down the road, we have an unfriendly Supreme Court, that the state can still go back to the strict scrutiny and say, hey, not here.
Right. Right. As it happens, the strict scrutiny clause is essentially inoperative since June 23rd, when the Supreme Court of the United States in New York State Rifle and Pistol Association versus Bruin came down with Justice Thomas's decision that has now instructed all inferior courts, that's federal and state courts, that when they're considering possible infringements on our Second Amendment rights, on the right to keep bear arms, they must review it by reviewing the text of the Second Amendment, and then the history and traditions, American history and traditions around that language, basically at the time it was adopted. And that any restriction must, if not have an exact duplicate of a regulation that was in then around the founding, but they must be a corollary. So obviously they didn't have any regulations about AR-15s back at the time of the adoption of the Constitution, but and so they can't say, well, they didn't have that law then, so we can't have that law now. What they can do is say they didn't have an analogous law then, so we can't have a law now. Or if they can find an analogous law that was widespread and traditional, then they might be able to justify such a law now. That's what the court has said. You have to do this. This is a much stricter standard than the strict scrutiny standard that we are placing here. So the strict scrutiny will only come into effect if the current understanding of the latest Supreme Court rulings is reversed or modified or maybe ignored. This would still be, the strict scrutiny standard would then still be incumbent upon Iowa's courts in Iowa with Iowa laws. But we think that the Judge Thomas decision is fantastic, and that it supplants this. Our amendment otherwise just says this is a fundamental individual right. Well, the Supreme Court has already said that.
Right.
It says it shall not be infringed. The Bill of Rights already says that. So what's controversial or reckless about that?
Yeah, exactly. Well, one of the things the anti-gun groups, and you see them, they're meeting on Facebook now and trying to rally folks to defeat this. And the Iowa Firearms Coalition does not have millions of dollars and countless bodies to counter what's coming up. But the phrase they like to use is the what we call the Freedom Amendment would stop common sense gun laws. So first of all, common sense, there is no common sense in some of these things we've seen proposed, not just in Iowa in the past, but other states.
Yeah, that's very subjective, but they do like to use that. The common sense gun reform, we call it gun control, which, as you know, as I mentioned before, this is actually control of the people. So this is a fundamental right. Americans deserve to maintain this fundamental right. They must do it as long as we have access to serious weaponry. We shouldn't have to worry about having to use it.
Right.
Once we no longer have access, if these people get their common sense reforms and limit us to single shots or double barrel shotguns or whatever, and make it very difficult to have any firearms at all, then we have to worry, because the history of the world has been that before a tyrant takes power, he eliminates access of his subjects or his would-be subjects access to weapons.
Yep. And then your freedom of speech and freedom of religion and everything else is out the window.
That's right. Then everything becomes potential privilege. You
Right.
may or may not be allowed to exercise it.
All right. So in 30 seconds, why is it so important that folks maybe that they haven't even heard about this until it's been in the news lately, turn over their ballot on November 8th and vote in favor of the language that will be on there? Basically, the sovereign state of Iowa is in favor of the Second Amendment. Why do we need folks to vote for that? Just encapsulate it briefly for somebody sitting in the coffee shop trying to explain it to their neighbor.
That's right. Turn your ballot over. I say page 2 for 2A. So on November 8th, turn your ballot over. Vote for the only constitutional amendment that will be on the ballot. It won't say Freedom Amendment, but it's the one. John,
Right.
again, this is the right thing to do. Iowa's one of only 6 states that doesn't have any protection, so that's an oversight that we need to correct. We've been working at it for a very long time. It's always possible that the Supreme Court decisions could be overruled, or something else could go awry there in the future. We don't know what it is. So let's lock it in, at least for Iowa, to protect this fundamental individual right to keep and bear arms.
Very good. Our expert, Richard Rogers, we thank you for an update on this, and just to encourage folks, help us out, join the Iowa Firearms Coalition, share the information about the importance of the Second Amendment and why, with all of our other natural rights, that we need to protect this. Turn it over, page 2 for 2A, like Richard said.
Right.
Thanks again, Richard. We appreciate your countless hours of effort on behalf of IFC. And until next week, have a good evening, and we'll see you next Wednesday on Warrior Wednesday.